All right, welcome everybody. My name is Kunle Ola, and I'm from the Thomas More Law School of the Australian Catholic University. I'm pleased to welcome everyone to this online webinar where we'll be discussing about the Nauru Declaration on Judicial Well-being. We've had over 250 registrations for this program from about 45 countries, and I think that's evident that judicial well-being is a crucial issue and that the Nauru Declaration is an instrument of necessity. Just a little background about the declaration. On the 25th of July, at the Regional Judicial Conference on Integrity and Judicial Wellbeing held in Nauru, the world welcomed the Nauru Declaration on Judicial Wellbeing. And I believe we are fortunate today to have some of the draft committee members present with us as panelists to discuss this declaration, to discuss its importance and the way forward. So I'd just like to thank every panelist for being here today and to thank the audience, also our attendees, for being here. The Honorable Justice Leach was meant to be, part of this panelist, but she sent word that she won't be able to make it today. So just wanting you to know, she sends her apologies, but also with a note from the Commonwealth Magistrate and Judges Association of their continued support. I would like to do a little housekeeping before we dive into the session. This webinar is going to run for 1 hour, 30 minutes, that's 90 minutes. And it will commence with a welcome address from Professor Patrick Kaiser, and then there'll be a keynote from Justice Matters. And after that, we'll have a panel session and, some questions and answers. So if you look at the bottom of your screen, you will see a Q&A. So please feel free to type in any questions or any comments that you may have. Please just understand that we might not be able to take, actually, we will not be able to take all your questions, but we will try to see how we put the questions together and, pass them on to the judges to be able to, take this on. Now, to do the welcome address is Patrick Kaiser. Patrick Kaiser is a former dean of the Australian Catholic University and of La Trobe University. He's a practicing lawyer. He's a mentor to many, and he practices in the area of human rights, constitutional law, and he has a scholarly interest in international justice for people in detention, the right to rehabilitation and risk management. He's a member of the Human Rights Panel of Queensland Parliament and regularly advises government and non-government clients in public law and policy matters. I think it's a privilege for us to have Professor Patrick Kaiser here with us to welcome Justice Matters. So thank you, Patrick. Over to you.
Thank you very much, Professor Ola, and it's really my pleasure to welcome all attendees and panelists to this extremely important online webinar on the Nauru Declaration on Judicial Well-being. Now, I acknowledge that it might be very late for a number of you. It's 10 p.m. here in Melbourne. And so thank you so much for your attendance. I'm looking forward to a stimulating discussion. We have an excellent team of panelists who will shed light on the Nauru Declaration. On the panel, we have the Honourable Justice Rangajiva Wimalasena, the President of the Court of Appeal of Nauru, Her Honour Judge Kaylee Cole, KC, Circuit Judge and the founder of the Judicial Support Network in the United Kingdom, the Honourable Lady Justice Jacqueline N. Kamau, Judge of the High Court of Kenya, the Honourable Justice Adrian Saunders, the President of the Caribbean Court of Justice, Ms. Sarah Carnegie, Director of Legal Projects at the International Bar Association, and Ms. Tatiana Veres, Crime Prevention and Criminal Justice Officer at the United Nations Office on Drugs and Crime. Finally, but very importantly, it is my distinct pleasure to welcome not only those panelists, but our keynote address, our keynote speaker for this event, and that's His Honour, the Honourable Justice Jose Igreja Martos. His Honour is currently the President of the Appeal Court of Porto in Portugal and serves as the Honorary President of the International Association of Judges. He's an active member of the Advisory Board of the Judicial Integrity Network of the United Nations and holds the position of Vice President of the Consultative Council of European Judges at the Council of Europe. His past roles include serving as the President of the European Association of Judges from 2016 to 2021 and as Director of the legal journal Julgar. Additionally, he is an Associate Investigator at the Universidade de Coimbra. an accomplished author. Justice Martos has written and co-authored approximately a dozen books on judiciary-related topics and has lectured in over 40 countries across all continents, sharing his extensive knowledge and expertise in the field of the judiciary. So please join me in welcoming the Honourable Justice Jose Iglesia Martos. The floor is yours. Thank you.
So thank you, Professor, for your kind words. Good morning, good afternoon, good evening, depending on the place of the world you are. In my particular case, it's still good morning, so maybe I will be brighter and hopefully warmer than those who are late in the night, as Professor mentioned. So my first words is to thank vividly to the Australian Catholic University in the person of its dean, Professor Kunle Ola, and for organizing this webinar and to allow us to share our project and to provide awareness on this so crucial topic. To acknowledge and to thank to my colleagues and institutions that were paramount for the Nauru Declaration, and a special word for my dear friend Rangajiba Vimalasena. His leadership was the main reason for the remarkable outcomes already achieved by the project. A very special word of appreciation and gratitude to those who registered to be present today, a large number of colleagues. This is very important for us, and we thank you for that, for taking your time to be with us. And of course, to the other panelists, some of them are very good and esteemed friends. My role is to briefly explain the importance of judicial well-being and to provide a first brief overview on the Nauru Declaration. So about the importance, as already mentioned, I was for 2 years president of the International Association of Judges. That is the biggest organization of the judiciary with 92 countries regarding judges. I was president of the European Association, 44 countries. Every single country, mostly in Europe, is present in this association, working extensively with Council of Europe, European Union, and other international bodies. There was something that is absolutely undisputable. In different parts of the world, in different countries, in different regions, speaking with judges, the issue of judicial well-being was always addressed. Even recently, a few days ago in Cape Town, my colleague from Chile addresses me and said that they have a huge problem with judicial well-being, issues on mental health of judges. They created a commission for psychosocial risk that is working on these issues, mostly connected with excessive workload of Chilean judges and the ways to deal with this situation. So it's all the time. If you, independent of the country, of the region, of course, judicial independence is our main core topic, but judicial well-being is something that is always present on the background. The reasons are, as you may know, very, I would say some of them are very obvious. They are generic, not only for legal professions, but related with modern society, digital society, dependence on technologies, isolation, now after COVID, still more pressuring, and all these general reasons that you are very well aware of. And many philosophers are concerned about that and writing about this, what is happening to modern societies. But, and this is my point, I think there are also specific and grave circumstances related in particular with judges. First and foremost, if you ask the main characteristic of our work, that will be solitude. Solitude. We must decide other people's conflicts. We do that with the law. That is also in crisis. Sometimes the law is very vague, open concepts, and much of the decision is delivered to the conscience of the judge. And this solitude of our work to be alone with our conscience, what the law provides in order to decide a conflict is taking its toll during the years, and especially not only for younger generations, but also for the oldest judges. Also the workload that is growing increasingly heavier in different parts of the world. The third reason that I would like to comment with you is the crisis of rule of law, is the debacle of rule of law. If you go to the rule of law index, we have now 6 years, consecutive years of decline of rule of law in many countries. This is an issue that is connected with the populist political parties and leaders, with authoritarian regimes, with the control that is put on judiciary by other state powers. This is obviously a reason for increased stress, increased problems about the judicial well-being of judges. Very recently, you can see in Mexico what happened. 7,000 judges expelled. They must now compete to return to their own posts. I cannot even imagine the toll that is creating on all these people, on their mental health, and on the stress that is provoked. But I could provide you with so many more examples, as you are very well aware. Also, social media. You can go to social media and easily know the name of the judge, the family member, a friend. You can be very aggressive on criticism. You can be even creating menaces to our work, only with a tweet, with a post, with something in Instagram, in Facebook, on Twitter, and that come back to us because we know about it. We have the possibility to know that we are being pressuring on social media. There is a more easy access to our private life, to our addresses, to our families, etc., etc. Privacy is jeopardized and easily put at risk. Also, the problems of security, especially in countries like Latin America, Africa, some European countries also, security of judges. With more complex crimes, with more complex criminality, we have more complex cases. The judicial files, the judicial cases, many times are of huge dimension and a very difficult management. The lack of resources to deal with such a complex situations. In some cases, the emotional involvement of our work. Look at family cases, family judges, knowing how families are in crisis in modern societies. Look at migrants, the cases related with migrants. We can read several articles, for instance, in UK, with the recent developments of judges working on migrant cases. Obviously, criminal matters, child abuse, poverty, degradation of social values. All this is creating a pressure, a terrible pressure on judicial well-being of judges. The pressure on performance. Now, with technology, we have daily statistics. By the hour, how many files are delayed. Everything is in the computer. You can see it immediately after you put it on the computer, how many cases we have to decide, how many, 3 days, 4 days, 3 months, 4 months. Each day it appears on our laptops what is happening. And as an announcing background, always the same, the solitude. As I mentioned at the beginning, we are alone with all these issues that I tried to cover briefly. That's why I was overwhelmed on how frequent the complaints, the cases were reported to me in different places, in different regions, in different situations. Also, as president of my court, recently, few days ago, I have a case of burnout of one of my colleagues. After some years of insisting in trying to put the case forward, she is now in a situation of clear burnout. We have an event recently about stress and burnout that was an event with an expert. There were around 100, 120 judges. And guess what? Day after, this therapist called me and said that five of the colleagues that were in this event phoned her in order to get assistance. This is the level of the problem we are facing at the moment. Something should be done. That is clear. We have some pioneer work from International Bar Association by the lawyers, but a sort of a miracle happened, to be honest, as quick, as transversal to different jurisdictions, and as inspiring as could be. And I'm talking of the Nauru Declaration, sorted out by UNODC. I was contacted by Marilo Cauchois, with the support of Tatiana Perez, also from UNODC, with judges coming from different parts of the world. That is very important to underline. With the technical expert, Carly Shriver, that is an Australian professor, that is a very good expert on these matters. With all this situation that was created in a few months only, in a short period of time, we achieved a result. There was a sense of urgency, a sense of commitment towards a topic that was so decisive in present days. And there was obviously a teamwork that was very effective. So I will ask to put on the screen, if it's possible, to briefly introduce the 7 principles. I like the number 7. You know, in ancient mythology, the number 7 represents this idea of fullness, of completeness, and this idea of going around the circle, tackling all the situation that topic will bring. So 7 is not it's not an incident. It's not by chance that we have this number 7. The first principle goes about the definition, obviously, the essentiality of the topic of judicial well-being. The second one, that is straight to the point, very clear language, goes against the bias. It's not a weakness to have judicial stress. Judicial stress is not a weakness. Then the language is very clear, and we put this in a very simple words, in a very clear words, and this is most important, addressing what we are addressing. The third principle about responsibility, and allow me to underline not only the individual responsibility of taking care, of trying to solve the problem, but also from institutions, because this is one important issue that I'd like to underline, the responsibility of judicial institutions in tackle with this problem. Ethics, absolutely decisive, a fundamental prerequisite. This is very well put it in principle 4, zero tolerance for corruption, for discrimination, for harassment. Without that, it's not possible to have judicial well-being. Then a fifth principle that is a very concrete, pragmatical one, and we try to be pragmatic on this topic. What to do about it? Prevention, management, awareness, to address the problem in a pragmatic way. The sixth principle is about there is no universal solution. We cannot count with an artificial intelligence generated solution. This is not possible. There are unique circumstances for each region, each jurisdiction, I would say each person that is dealing with the problem. So this cannot have this technical, broader approach that is provoked by artificial intelligence or something like that. This is a very human problem. And finally, the last one, if I may say so, my personal favorite, has to do with the systemic and comprehensive approach, because we are talking about human rights. We are talking about the human rights of judges. We are talking about human rights of judicial officers. If we don't have the freedom of expression, freedom of assembly, judicial independence, to have a judicial impartiality, to get rid of external control or pressures, it's not possible to speak about judicial well-being. In the end of the day, rule of law is paramount for an effective way of having judicial well-being. And this is it. This is the message I wanted to put forward to you, to provide time also for discussion and to move forward on other issues that are contemplated by our declaration. Thank you. Thank you very much.
Thank you very much, Justice Matters. It's really insightful listening to the experiences of judges that you've provided. You know, at times there is this misconception that judges are like semi or demigods that don't feel anything, but really they are first humans that go through the same mental torture. And just, you know, the examples you were given about the things that happen on social media, these are realities. It's evident that the Nauru Declaration, and thank you for taking us through you know, quickly the you know, the 7 principles. And I think it lays the foundation for us going into the panel session. And I would like to introduce the moderator, my co-convener, that's Dr. Anne Pickering. She is the course coordinator for our law program here at the Australian Catholic University. She teaches in the land law related subjects, and she's an excellent teacher and researcher. And I hand over the panel to her. Thank you, Dr. Pickering, for chairing this session.
Thank you, Dr. Ola. Good morning and good afternoon and good evening, everyone. It's my absolute pleasure to moderate this session today, panel session today. So we've gathered a remarkable group of leaders, each contributing in very unique perspectives on judicial well-being. With that, I think let's dive into our discussion and let's hear from the panelists. So to start with, I have the privilege of posing the first question to the Honorable Justice Rangajeeva Vimalasena, President of the Nauru Court of Appeal. Justice Vimalasena, you served as the convener of the drafting committee, and you're truly, I think, the visionary behind the Nauru Declaration. You collaborated so effectively with judges from around the world to accomplish this really significant project. So, Justice Vimalasena, what inspired you to initiate this project?
Thank you, Dr. Pickering. First of all, I think I should thank Professor Andrew O'Neill, the Executive Dean, and Professor Kunle Ola, and Dr. Anne Pickering of Thomas More Law School, as well as the Australian Catholic University for this opportunity. And I must say the journey to drafting the Nauru Declaration was inspired by multiple factors. As we know, judges around the world are expected to perform their duties under intense scrutiny, and they manage substantial caseloads and often face considerable isolation and stress, as Justice Mathos just now said. So when these challenges go unaddressed, they don't only impact judicial well-being, they ultimately undermine the quality of justice we deliver. So the realization sparked my commitment to bring judicial well-being to the forefront as a priority. So I have seen judges during my career in very different contexts, struggling with issues such as high levels of stress, emotional demands, and urgent need for more institutional support. And I remember back in Sri Lanka, back in 2014, I was the secretary for the Judicial Service Association. And having seen all these things, I experimented with engaging judicial officers in monthly performing arts workshops as a means of supporting them to manage stress. And at that time, even my own colleagues were skeptical about it because at that time, judicial well-being was something hardly heard of. So a few years later, I came across the study on judicial well-being done by Dr. Carly Schruer from Australia. And also I had the opportunity to listen to the personal experiences shared by Judge Callie Cowell. And I must say, and both of them became, a few years later, both of them became members of the drafting committee as well. So all these things inspired me to do something impactful as judicial well-being isn't merely a national issue, but a global one that requires international action. And also, I must acknowledge the support given by the UNODC and particularly Mariushua and Tatiana. So this whole process was indeed a voyage into uncharted waters. The whole drafting process was done online, as Justice Mato said, and it was a very challenging task. We had committee members representing all continents, various regions, and a number of judicial organizations. So sometimes they had to attend online meetings even during odd hours. So a lot of effort was put in by each and every member of the draft committee to craft these 7 principles. So Dr. Pickering, to answer your question, I must also say that Nauru Declaration is more than just a document. It represents a global commitment to supporting judges, and the 7 principles encompass a wide range of issues aiming to raise awareness, acknowledge the challenges of judicial stress, and most of all, to inspire action.
Thank you, Justice Vimalasena. It's really good to hear how all of this started and really the vision behind it. Your commitment to collaboration and innovation in the judiciary is, I think, truly inspiring, as we heard from Justice Matos as well. I think it highlights, listening to you, I think it highlights the power of collective action in addressing common challenges that judicial officers face. Once again, thank you, Justice Vimalasena. My next question is to the Honorable Justice Adrian Saunders, the President of the Caribbean Court of Justice. Justice Saunders, you are a highly respected judicial leader in the Caribbean. You have contributed greatly to regional judicial outreach as well as judicial educational efforts. So my question to you is, could you share the measures taken in your region to address judicial well-being? And also, Justice Saunders, I would like to hear from you. How do you believe your role in the drafting committee of the Nauru Declaration could influence judicial well-being on a global scale? Thank you.
Thank you very much, Dr. Pickering. And it really is a great pleasure to share this space with such esteemed colleagues from around the world. And I extend my thanks to the Australian Catholic University for this opportunity. In our small Caribbean societies, expectations of our judges run incredibly deep. Judicial conduct is carefully scrutinized by the public, and judicial well-being impacts on judicial conduct. As a result of the work that has been done in this area of wellness, especially by the Caribbean Association of Judicial Officers, or CAJO, there is now, I would say, a better appreciation of the role judicial well-being can play, not only in improving the health of an individual judicial officer, but just as, if not more importantly, in promoting judicial integrity. Over the last 10 years or so, concerted efforts have been made to alert judges to the relevance, to the importance of judicial wellness, and to the insidious dangers of judicial stress. After it was observed that when we had our various judicial education programs, the sessions on judicial stress were among the most heavily subscribed by judicial officers, CAJO decided to carry out a wellness survey in 2021. We received responses from 126 judicial officers. And the responses were a wake-up call. A quarter of the participants stated that they never felt or did not often feel happy or fulfilled. Work was rated as the largest contributor of stress. Almost 17% reported that stress had a significant impact on their delivery of judgments and on their decisions. And almost 20% reported that stress had an impact on the effectiveness of their case management. So in light of these results, CAJO encouraged individual judiciaries to engage in various types of initiatives. And CAJO itself intensified its programs to alert judges to the importance of judicial well-being. CAJO's newsletter of July 2021 focused exclusively on this issue. And at our biennial conference in St. Lucia in 2022, a plenary session was held where we identified wellness challenges and causes of stress, and we explored techniques that could be used to mitigate judicial stress. Since then, we have hosted online programs that have addressed the issue, and individual judiciaries have engaged experts in the field to conduct in-person wellness sessions with their judicial officers in order to better provide them with practical coping skills. So the Guyana judiciary, for example, facilitated beneficial sessions for couples, families, and even one-on-one encounters. An expert introduced yoga sessions for that country's judicial officers, and Chief Justice Roxanne George reported that the yoga was a huge hit with the judges. They were taught and encouraged to engage in relaxation techniques, not just to be done at home, but also that could be initiated throughout the day while at work. Elsewhere in the region, some judges have shared about the deeply therapeutic effects of simple gardening and have encouraged other judicial officers to take up this hobby in their spare time. The Trinidad and Tobago judiciary had long ago deployed a weighting mechanism to ensure that there is an even distribution of cases among their judges. At my own court, the Caribbean Court of Justice, there are only 7 judges and some 75 or so staff members. And we have launched a program, it's called the Employee Assistance Program, where we offer various counseling and other services, principally to the clerical and administrative staff. We've also set aside a room in the court where judges and staff alike can de-stress after hours by playing various indoor games. As the declaration states, judicial well-being is never done. It must always remain on the agenda. And so we are constantly on the lookout for other ways in which we can reduce judicial stress and promote healthy options for judges and staff alike. As to the second question, I don't know that I can really single out my role. And even if I could, it would not be fair or accurate. The declaration was a truly collective effort, and each member of the drafting committee had a critical input. Given, I think, our diversity, our varied life experiences, the different cultural, legal, and social environments that have shaped our assessment of this phenomenon of judicial wellness, I believe we were able to produce a document that truly has global significance and reach. And it has drawn attention, or it has necessarily implied, several salient issues, including the one that Judge Mato stressed, which I believe is extremely important. The source of justice administered in courts is not a divine being. It's a human system, and it is dependent upon the collective human capacities and faculties of individual judges. And therefore, we have to pay attention to how these human beings are able to do their work without being overburdened and without suffering from burnout. Thank you.
Thank you, Justice. Thank you, Justice Saunders. Thank you for sharing your experience. As I was taking notes, it took a page and a little bit. It's awesome to see your proactive approach in addressing some of these issues that we've discussed. And I think it also highlights the important link between regional initiatives and the global impact, that Justice Vimalasena mentioned. So I look forward to an extended discussion to hear your significant experience in this area. And with that, I would like to move to our next speaker, the Honorable Justice Jacqueline Kamau, Judge of the High Court of Kenya. And She brings a wealth of experience and perspective to this discussion this evening. Justice Kamau, recently we saw the tragic loss where a Kenyan judicial officer was shot while at work. I think everyone is entitled to a safe working place or workplace, including judicial officers. So my question to you is, as a strong advocate for the rights of judges, do you believe judicial well-being is sufficiently addressed within judiciaries today? Thank you.
Thank you very much. First of all, I want to welcome all of you to this webinar and to say greetings from Kenya, which is the eastern part of the world, East Africa. So I welcome you. This is afternoon. And thank you to Australian Catholic University also for inviting me, and to Justice Rangajiva and Dr. Pickering for the very good moderation. Now, to that question, I want to say one or two things. First is that this was a very isolated incident, that we've never had a case like this where we've had somebody who has been attacked, right, with a gun, for example. But of course, we've had other instances whereby accused persons perhaps maybe have thrown human feces on judicial officers when they're delivering the judgments, because that is still, their security is still not guaranteed. Or we've had cases whereby people have also been attacked using bottles, because I've had one of the judges a person threw a bottle to him when he was already delivering a judgment. So, and many times some of these missiles are, brought in through the prisons. So the judges maybe have done all that they need to do because they have left their security to the people who are arranging that, because my job as a judge is to deliver justice, or a judicial officer. Because I think here the issue is not only us judges, the issue is also the magistrates who are also involved in these particular cases. We've also seen other instances. I remember recently, I think in the US, where there was a police officer who also entered into the chamber of a judge, and they killed the judge as well. In Colombia, I think at some point, there was an entire court was eliminated by terrorists. So it's something that is affecting all of us. It's only that in Kenya, it happened at a time when we were not expecting it to happen. Now, the reason I've given that background is that we in Kenya are trying as much as possible, as we've heard from the keynote speaker, Justice Matos. We are working with performance, and everybody's working very, very hard. So you do not want your matters to be taken out. So some of these places, because we do not have resources, we have then tended to create our own resources and be innovative. So in this particular case, there was a tent, which is outside, because the judiciary is trying to deliver justice, because we are saying, if you delay justice, then the justice denied. So we have done the best that we can. So in some places, they even go out and sit under trees because there's no infrastructure to listen to these cases. So as a judiciary, we have done the best that we could, but I now move it to the other arms of government and say that even as the judiciary is trying to safeguard its people, it is not able to do that without resources. As a judge in Kenya, I am given a police officer who is a driver and a bodyguard. They are both armed. But remember that I do the same kind of job as a magistrate does. But the magistrate at the end of the day will not get into a car which has got security from a police officer. They will go into public means. And they will get into a public vehicle, which is the same vehicle that an accused person who they were with in court and who has bond is definitely going to enter. For that security, it cannot really, it's obviously very compromised. When I was the president of Kenya Magistrates and Judges Association, we did try as much as possible to try and sensitize the executive and the police officers that we need to have even the magistrates themselves guarded. Many of our houses where we stay in, you find that we are not able to have adequate security. And for that reason, I'm not able as a judge to perhaps do the independence, to the Banglo principles, for you to be neutral, for you to be impartial, for you to be independent, because if somebody already is threatening you, sometimes you might find that your decision-making is compromised. So I feel that allocation of funding by the executive, we are not in competition with them. We are simply complementing a part of a system that needs to ensure that the work goes on well and the society moves in a proper structure, because otherwise even the executive will not be able to deliver the services. So we are an integral part of the three arms of government. So legislatures and executive then need to ensure that they can come up with the ways in to support the judiciary. So I say that that interfaces very well the issue of security to the principle number 1 of the Nauru Declaration on the judicial well-being. That is, it is essential and it must be recognized and supported by everybody, not only the judiciary. So that's what I'd like to say. Thank you very much.
Thanks, Justice Kamau. That was really interesting. And thank you especially for providing that background information on that case. But your feedback highlights an important aspect of judicial safety and well-being, I think. It also reminds us that every judge deserves a safe and secure environment where they can work towards upholding justice effectively. So thanks again, Justice Kamau. And I think I should now move to the next speaker. I'm delighted to welcome Her Honour Judge Kelly Cole, Circuit Court Judge of England and Wales. Now, Judge, you're the founder of the Judicial Support Network, and this network is to support judges, and your work in this area is significant. I know 5 minutes is such a brief window to share your insights. So let me go to the question straight away. Judge, my question to you is, could you explain what the Judicial Support Network does, and how do you believe the Nauru Declaration will impact the dynamics of judicial well-being? Thank you.
Thanks, Anne. Can I say, first of all, thank you to everyone. Thank you so much, the Australian Catholic University, for the work they're doing with this project, which I have already said to them and will keep on saying, is going to be a legacy for your university that exists far beyond our lives and will, with the help of the UNODC, which will still exist even if we're not there, carry on with the judges who have yet to be born. So please understand, it sounds interesting, but perhaps a bit niche, but this isn't. This underpins the structure of the judiciary of the future. And I secondly say, here it is. Happy Diwali, everybody, and blessings from an Indian in London. It's Diwali today. And I was appointed a circuit judge on Diwali 9 years ago. And so briefly to explain, firstly, views expressed my own. They're not on behalf of the judiciary of England and Wales. A lot of them don't even like me, and they really don't like me expressing my views. So just take that on board. Secondly, I had 6 really happy years. I've been 41 years now in law. 6 really happy years as a part-time judge, so a fee-paid judge, a recorder of the Crown Court. I never saw a single problem, never had a single problem. Treated so well by everybody at every court. I became a judge on November the 9th, 2015. What I didn't realize is 9 days later, my career was over. It was finished. I just didn't know it. Thereafter came years. I won't spend time. There's no time to say what happened, but things happened. And I tried at first to do it gently. Could we have an anti-bullying code? Could we have some thought about judges of colour being treated differently? Because we are. There's no point pretending that we're not. We are. About women judges, about issues that affect judges, disability, allocation of work. Can we talk about it? No need to talk about it because there isn't a problem. Look at that important judge and that important judge. They're brown, black, they're doing really well. Something wrong with you. Okay, can we talk about bullying? There isn't any bullying. Why are you saying there's bullying? Judge A and B say there's no bullying. There's no bullying. I tried gently. I tried then less gently. And I thought, okay, well, I'm just going to keep going. By then I was disabled. Again, I didn't know it was permanent. I didn't know the extent to which I was going to be affected every day of my life, but that's fine. It's not a pity party, it's a fight. Then in 2018, a worse phase occurred, worse in the sense that I was beginning to get a little bit better. And my health went into free fall. And then I started looking at the issue of litigation, not to attack, but to protect myself from the continuing ill treatment that I was facing. And I started a project of trying to find out what was happening in the judiciary in England and Wales, our perfect country, our wonderful judiciary. And there are wonderful judges, and it is a wonderful country. but there was a lot wrong. And so I established quickly, quite quickly, at first it was people of colour. Naturally, knowing I was of colour, judges of colour came to me. Then I was joined by Claire Gillam, who, along with me, have probably achieved the two most important things for, I think, for welfare in the judiciary that have been achieved. Joined me and said, well, what about women? What about women who are white? And I thought, okay, them too, all right. And then I was approached, I won't say his name, he's not here, and I don't know if he'd be comfortable, but a judge of many years standing, very senior, who telephoned me and spent about 3 hours on the phone with me, where we both cried most of the afternoon at our experiences and said, what about us, Callie? Do you really think white men aren't treated just as badly as all of you? And I thought, interesting. Okay, so we set up the Digital Support Network. What I did was I set up a committee where we looked thoroughly at every aspect that we could, and we developed a help page, which is available to every member. And in that help page, we dealt with things like safe and confidential place to raise concerns or seek support. Safe is important. No one's going to judge you and no one's going to tell of you. Health issues, everything from disabilities before entry to the judiciary, disabilities as mine that occurred afterwards. Reasonable adjustment. Are people supported? Is HR helpful? How can you ask for reasonable adjustments? How can you ask to move? Is your advancement being held back? Why is it being held back? Work allocation. We're treated differently. Work is given to people who are helped, who are liked better than us. And it affects our career, affects our development. It is one of the reasons I believe that there is not more diversity in the British judiciary. And I am treated differently every single day. Believe me, I know that. I complained about it only yesterday. Then working environment, security, safety, treatment by leadership judges, by presiders, how to make freedom of information requests, how to make a data subject access request, how to deal with complaints, whether made by you or against you, how to deal with a judicial conduct investigation authority, how to whistleblow, because as I'm about to tell you, the two most important things I think happened was Claire Gillam spending 7 years taking her case to the Supreme Court, which recognized the first time in October 2019, the judges are covered by the Human Rights Act, by the European Convention on Human Rights. We have rights. We didn't know that, but we do. We're also workers in the sense we can be treated as workers. And therefore, Baroness Hale, in a unanimous decision of the Supreme Court, said that we should be able to speak out. We should be able to talk about the effect of the lack of legal aid on families. We should, as Claire did, be able to talk about the fact that her security wasn't being affected. She was being chased by a man with a knife regularly, and HMCTS weren't doing anything about it. But instead, she was sacked for doing that. But anyway, she was reinstated. She carried on fighting. She then passed the baton to me, because the main issue we still had outstanding was that everybody who tried to commence an action or do anything were given the same answer. There's no duty of care to any judge in any circumstances owed by the Lord Chief Justice, by the Lord Chancellor, or by the Ministry of Justice. Therefore, you're on your own. It's free fall. We can do what we want. We don't have anything to do with you, which is a weird system when you think they're regulating every minute of our lives, disciplining us, telling us what work we can do, what we can't, when we can have leave, when we can't, whether we can progress, when we can't. But yet, there's no duty of care. Now, I took advice from the best equality silks in the country. I spent 5 years' salary. I commenced litigation, not because I wanted to calm or obtain money. I've lost 5 years' salary. But rather, I want to set up a system which protects judges of the future so that no one is treated as Claire and I have been, or our other judges who I won't name. And I established it. So in July 2021, the 2nd of July, finally, as halfway through my action wasn't finished, concession was made, admission, that not only did they have a duty of care, but they'd had a duty of care since legislation in 1946. They just hadn't told anyone that or really thought about it. So that has changed it's changed everything. It's changed the landscape. For 5,500 judges, it means every judge in the country is owed a duty of care. And I've had so many thanks from judges I've never met across the country saying, thank you, Callie. I said to this person when I have the problem with disability, with deployment, with menopause, with anything, I just said, duty of care. Callie, cool, duty of care. So that is, I've helped people. We've helped people. And so we did that. And we also had two main objectives. One was to be the friends that you didn't know you had, but you really needed, the friends you can ring at 3 o'clock in the morning, the friends who are going to hold you up. And we have had 2 attempted suicides. We have had a number of close suicides, including 2 of my own, so and others, and ongoing. And we are literally there. We can be the first port of call, the last port of call. We work with the judiciary, not against them. I introduce them to HR if I can. We arrange counselling. We put them in touch with other things like I've had EMDR and things like that to help them deal with things. We go to them with meetings with their leadership judges, with meetings with HR. So that's the more of a kind of pastoral but important role, because all the judges I went to and associations I went to when I needed help, the doors closed, the backs turned. There were lots of nice judges. We have fantastic judges, and I've grown up with a lot of them, but no one wants to rock the boat. No one wants to put their head above the parapet. And I thought, well, you know what, my career's over, so I'm going to just do this. So that's what we did. We set it up, and then we came to Nauru, and there I'll stop.
Thank you, Judge. I would love to listen to your story, and I knew you. When I read your profile, you would have a very interesting story to hear. So perhaps we will come in our second rounds to ask you 1 or 2 questions. But for now, can I say, first of all, thank you for that touch of festivities. It's wonderful. But more than that, thank you. Your experience is inspiring, that inspiring insight into real issues, I think, and how you forged a path for supporting judicial officers. So that is quite inspirational. The foundation, I think, that you've laid with the Judicial Support Network is really a testament to the importance of support systems in maintaining judicial well-being. Once again, thank you, Judge. My next panelist is Sarah Carnegie. As the Director of Legal Projects at the International Bar Association, Sarah, I believe you've worked extensively on well-being issues. As an important stakeholder in this process, I'm really interested in your opinion on why does the International Bar Association consider judicial well-being an important matter? And if you can also add to that, how can enhancing judicial well-being impact the overall delivery of justice?
Thank you very much, Anne, and obviously thank you so much to the Australian Catholic University for inviting me to be here to share the work that's been done by the International Bar Association in this space and in other interconnected areas that all feed into having a healthy and well-functioning legal profession, not just judges, although that's the core focus for today, but also the overall legal profession, which underpins a democratic society, underpins how the rule of law is being respected and looked after. And in essence, if judges are unwell, as has already been said by Justice Matos and others, then it's clearly a big problem in how the world is operating, in how justice is being dispensed in our courts and by our lawyers, who are in absolutely integral to deals and scales of work across all areas of activity in society. So the IBA recognized that this was an increasing problem based on research and study. And in 2019, our then president, Horacio Benito Netes, he commissioned a task force to look into this, to try and come up with some recommendations on what the International Bar Association should be doing more broadly in the context of well-being within the profession. And that delivered its report in 2021, having looked at over 3,500 respondents, both from individuals and also from institutions, bar associations and law firms, to understand what was going on. And clearly came up with some seriously worrying data about the prevalence of mental well-being difficulties experienced by professionals all over the world. So this is not just a problem in certain regions. This is a global issue across all ages, all demographics, and including the judiciary. And we see that, I won't go into it because I haven't got the time, but of course, all the different studies that have taken place in many areas of the world that demonstrate that the judiciary is by no means exempt from this. So this is a global phenomenon in the legal profession. And we came up with 10 recommendations. And what has been really interesting to see is the extent to which our recommendations also support and feature within the Nauru Declaration. So key aspects include the fact that it matters and it's not a weakness. This needs to be seen as a fundamental pillar of what upholds the system, and seeing it as a weakness and stigmatizing it is a fundamental bad place to start, because then people don't come forward and speak, and we don't get activities to address the issues. So awareness is then crucial. There has to be commitment to change, and that needs a regular and ongoing assessment. Again, part of what we've seen and heard today. This isn't just a one-off policy development that's then put on a shelf and we hope it works. This is a regular communication point with important policies that adapt as systems adapt. We need to keep that dialogue and the communication open to address these issues, recognizing intersectionalities, the issues affected by women, and I'll come on to parts of that in a moment. And of course, the key issue is sharing good practices and learning from others. So this is an isolated domestic question. And that's another reason why the Nauru Declaration is so important, is that we create the global community. And the UNODC has been fantastic at pioneering that through its high-level integrity network. So I'm really thrilled to see this and want to be able to support it through the IBA's Wellbeing Commission as we move forward and into 2025. There is, in fact, a part of the IBA's Wellbeing Commission work that specifically looks at judicial well-being. And while the work that's being done in that space is currently at an early stage, one of the things that we've been we've been considering is how would we address the three different elements of how a judge works. So looking at the system, so the system dimension means looking at the structural and operational aspects of judicial work, looking at the courtroom, the psychological health and safety in that space. Secondly, looking at the human dimension of a judge. So looking at the personal and interpersonal aspects of being a judge, focusing on peer support, community engagement, stigma, all of these issues to try and address the individual's experience. And then finally, the ethical dimension of a judge, and this fits into other really core work that I'm leading within the IBA at the moment, which is looking at the ethical responsibilities of judges. And the work we're doing more broadly is looking at the role of the lawyer and the ethical responsibilities and role of the lawyer. But the importance of their well-being, as has been mentioned by everyone today, on upholding the rule of law and ensuring justice and the administration of due process. So those three dynamics, what can we do targeting each of them? And we're looking to see whether working with others, including the UNODC and the National Center of States Courts in the USA, whether we can develop some kind of program of work which we pilot initially and then look to roll out after receiving feedback on its efficacy. So these are things that we are looking to do in recognition of the paramount importance of this work. I would also say that this also links to work we're doing in the context of gender representation across the legal profession. And we're looking at the judicial sector, in-house lawyers, private sector law firms and government lawyers across multiple countries and doing reports. We issued our 10th report yesterday on Ukraine, but looking at the number of women who are represented at the most senior levels of each of those four sectors and the initiatives and support that is being put in place to assist and to develop careers. So this is obviously an important feature around awareness raising of representation of women at the highest level and keeping them there. So clearly recognizing issues such as menopause, bullying and sexual harassment, and other aspects that feed into the well-being of judges. So there's so much I can say on this work on bullying and sexual harassment, etc. But I'll leave it here in the interest of time and look forward to questions in due course. Thank you.
Thank you very much, Sarah. That was really enlightening. And I'm quite familiar with the work you've discussed because I worked at the Queensland Law Society here in Queensland, and I was part of the wellbeing rollout, which they did quite a years ago in 2011, 2012. So thank you for giving your perspective from the legal profession on this important aspect of judicial well-being. And thank you very much. So let me move to the next panelist, Tatiana Veres. Tatiana Veres, I am quite interested in in the global study that UNDOC undertook. In 2021, you were involved in that global study, which explored the linkages between judicial well-being and integrity. I think this is a very important initiative. So my question to you is, what are some of the key findings from that study? And as a member of the Nauru Declaration drafting committee, how do you see these findings helping judiciaries worldwide?
Good morning, afternoon, evening, everyone. I would like to first extend my heartfelt thanks to everyone present in this webinar, in particular to the Australian Catholic University and Justice Rangajiva Wimalasena for the invitation to join this esteemed panel. I am truly honored to be here alongside such distinguished judges and experts, including two members of our advisory board, Justice Jose Matos and Justice Adrian Saunders. So maybe let me start by briefly explaining why we have been exploring the links between judicial well-being and integrity. Our Global Judicial Integrity Network, as the name suggests, is focused on promoting judicial integrity. And we work with judiciaries and try to help them implement relevant international standards like the UN Convention Against Corruption and the Bangalore Principles. And just as importantly, we also aim to create opportunities for judges to connect and to share knowledge, experiences, and struggles, which is in fact central to our mission of being a network of judges for judges. And our focus spans a variety of judicial integrity related topics, and judicial well-being or well-being of judges probably might not seem like an integrity topic right away. However, we believe it is strongly tied to integrity. Judges who are overburdened, stressed, or burnt out are less able to meet the high standards of resilience and focus that their role requires. In this way, judicial well-being is a matter of integrity. It impacts public trust in the judiciary and the quality of judicial decisions. Our 2021 well-being survey and the subsequent 2022 study were born out of what we heard from judges during the pandemic. Feelings of isolation, growing backlogs, escalating stress and anxiety, often with no support from their judiciary. This feedback drove our research, aiming to shine light on judges' experiences and needs, and it resulted in findings that confirm a broader ongoing issue beyond the pandemic. With responses from over 750 judges in 102 countries, we found that 76% of judges feel they don't have enough time to maintain their well-being. Over 90% experience stress, with heavy workloads as the biggest factor. 69% feel mental health is still a taboo topic in the judiciary. 83% of judges believe the judiciary's support in this area is insufficient. And 97% of judges think more prominence should be given to promote judicial well-being. And this last finding in particular supports why the Nauru Declaration is important. Judges' well-being is essential to the quality, fairness, and positive perception of the courts, yet it often receives little recognition, and in some countries the concept is almost unheard of. Raising awareness and providing better support is essential, and we are therefore pleased that our research has also helped spark new initiatives focusing on this important area, including the Nauru Declaration. In closing, I would like to share a few quotes from our survey that capture the judges' own words on these issues. There are relentless and crushing workloads and insufficient time to research matters properly. We are always behind and pushed into the next list. We work solving the conflicts of other people. We have contact with very varied crimes, unpleasant and even horrible actions. We need a work environment that helps us minimize the effect of that reality. I would welcome more training and programs to assist in the de-stressing. Do not just do a seminar once a year and think that is enough. Unfortunately, my single experience with the topic is a webinar organized by the UNODC Global Judicial Integrity Network. These are some powerful words. Thank you again for giving me the chance to discuss our work and be here with you today.
Thank you, Ms. Ferris. Thank you very much. I think the UNODC study highlights that important relationship between well-being and integrity in our judicial system. And I think it also offers a roadmap for improvement. So thanks again for your response. I think it's time for me to check whether we can take more questions. And I think we might have time for 1 or 2 questions. But before that, can I say, all the comments from the panelists have given us a really good understanding of the formation of the Nauru Declaration and the significance of judicial well-being. So with that, I want the second round of questions. I think we might have 2 questions. First question, Justice Vimalasena, we heard some exciting news about another initiative, and I think that you have proposed to the Republic of Nauru to submit a resolution to the United Nations to declare an International Day on Judicial Well-being. So would you like to share this exciting news with us, please?
Thank you, Dr. Pickering. Actually, once we have adopted the Nauru Declaration on Judicial Well-being, we wanted to take this dialogue forward. So we wanted to establish something that would continually remind the global judicial community of the importance of judicial well-being. So we made a proposal to the Republic of Nauru to submit a resolution to the United Nations to declare 25th of July as the International Day for Judicial Well-being. That's the day that the Nauru Declaration was adopted. And I'll take this opportunity to express my gratitude to the Honorable Minister for Justice of Nauru and the Republic of Nauru for recognizing the significance of this issue and for agreeing to bring this proposal forward to the UN through the Nauru Permanent Mission there. And they're actually working tirelessly on this at the moment. And we are hopeful that this International Day on Judicial Well-being will soon become a reality. And I believe such a dedicated day would give us a global platform to acknowledge the challenges the judicial officers face worldwide and to inspire collective action to promote judicial well-being. So I know that this is something that all the judges around the world can look forward to. And so we are hopeful it'll become a reality soon.
Thank you, Justice Vimalasena. Thank you for that. And I think we might be able to squeeze in 1 question. And I would like to ask Justice Kamau, because Justice Kamau, you mentioned that safety and delivering justice is important in your jurisdiction. So as you know, the Nauru Declaration in Principle 4 emphasizes the importance of fostering an ethical and inclusive judicial culture. Can you share with us really briefly whether your jurisdiction has taken any steps to address judicial bullying and harassment?
Thank you very much, Dr. Pickering, for that question. Indeed, it is true that for sexual harassment and bullying, we have taken quite a bit of a stance. Because one of the things that we want to say is that our Chief Justice was a member of FIDA, International Federation of Women Judges. So she's very keen about the sexual harassment. But we must agree that sexual harassment does not only affect women only, it does also affect the men. So as I speak about this, we already have a sexual harassment policy in place. And there's already a reporting mechanism of how, when this happens, then you can be able to take the matter forward. Because obviously, when you find that there's that power imbalance, issues of fear of people losing their job or being harassed or even being victimized is very, very high. The next thing about the bullying is that already in our judicial code of conduct, we have it there as bullying, because bullying also is also tied to sexual harassment, because you find that the person who is bullying you, they're not bullying you for any particular reason. They're bullying you because there's they have more power than you are. So that is also part of the judicial conduct. Now, if you fail to adhere to the judicial code of conduct, then this is one of the ways in which you can actually be removed as a judge, because then you're not fit to be a judge. So as Kenya, we have taken it very, very seriously. We have had, of course, maybe instances, but they're not really out in the open, because obviously we know nobody will want to say that they're being harassed, or the harasser and the harassee. But now with the new mechanism, which is very confidential, we believe that many more cases will come up and we'll be able to handle them. But so far, so good in Kenya.
Thank
so
you.
both sexual harassment and bullying, we are taking care of that.
Thank you,
Thank
Justice.
you.
That's an excellent initiative, and it's really good to hear of the proactive measures that your jurisdiction has taken. So I think to wrap up from my end before we move to the next segment, this discussion has highlighted really the multifaceted nature of judicial well-being and its impact on the justice system. So I think as we move forward, as we've heard from the panelists, let us continue, I think, to prioritize judicial well-being and justice and society at large. So although there are so many aspects to judicial well-being that we want to discuss on this topic, since time is of the essence, we want to move to the next segment, and I will now hand over the session to Associate Professor Kunle Ola to take some questions from participants. Thank you.
Thank you, Dr. Pickering, and thanks to all the panelists for your inspiring thoughts. We have some questions from our attendees. A lot of them are quite similar, but I would like to direct this the first question to Judge Kelly. The question says, it seems that, and it says I might be wrong, this judicial well-being issue is mostly an initiative from third world country judges. It says, are the judges from developed countries less stressed, or their well-being is already addressed by their respective states? So, I mean, I would allow you to address the question.
Thank you. No, I don't think we're less stressed. I think that the importance of the declaration and all the work of UNODC and others is to show what we have in common, not that are different. I don't think we should differentiate between third world countries and others. There is a huge amount of judicial stress and problems within England and Wales. Some of it caused now, literally now, by policies which have meant that we have huge backlogs, and instead of supporting those backlogs by giving us more resources, the new government has cut the resources. And so we've gone from a 16 court centre to 11 court centre. We can probably only sit 8. Our diaries now, we're going to have to tell rape victims that their cases are going to go back another 2 years. They've waited 3 years already. People are going to be kept in custody unnecessarily. People are going to be released from custody when they maybe shouldn't. And so we are dealing with all those things and all the other issues. So I think it is everywhere. I think the advantage we have, which is one of the reasons we're setting up the Global Judicial Support Network, is that we can talk about it more. There is some counselling. There is some ability to talk about it. The press will cover it a bit. So I do think in other countries where the judiciary is very small, the impact of talking about mental health and other matters is so difficult that people don't talk about it because they're afraid of losing their job or their reputation. And so that's why we're setting up a global network, which will have therapists, counsellors, psychiatrists, and judges available all over the world, so that you could, if you're a judge in Kenya or you're a judge who's actually fine, because it sounds much better than England well, or you're a judge in Sri Lanka or anywhere. So I could have a judge that's helping me from Uganda, and I could have a therapist called Diane from Trinidad. And so no one's ever going to know who I am, what I'm doing, who I'm asking. The only person that will know is probably me and 2 others who will do the triaging, and I won't know much. So in that way, we hope to support judges all over the world, not by interfering in anyone's legal system or interfering in their political systems, literally to provide a family support structure. So, and that crosses all the differences that we have, because although we are different, essentially the problems, you'd be surprised, are just the same. It doesn't matter where we are, it's the same problems.
Thank you, Judge Kelly. I mean, and I think it's really important. Yes, we may be, you know, some may be living in developed world and some may be living in the third world, but judges are judges. They face the same challenges. The societal circumstances may be different, but the human aspect of what they go through is basically, you know, similar. And therefore, it's not a third world, you know, focused issue. So Nauru Declaration is not a declaration for, you know, just the developing countries or the third world country. It's a declaration that affects all judges. And I think this brings me to the second and the third question, because they are quite similar. You know, the person noted that it's essential for the associations representing judicial officers in these regions to actively engage in initiatives that promote the welfare of their members. And I will just take it with the, you know, third question that basically asks the question that how can we all get involved in furthering this declaration and being a part of it? So Justice Saunders, are you happy to please help address, you know, how can anyone who really wants to be more involved, you know, actually get involved? What can we actually do to see the Nauru Declaration, you know, become implemented in our different regions? Thank you.
Thank you. Thank you for that. I think when we examine some of the sources of stress, some of those sources relate to actual stress which is engendered in the justice system, in the courts themselves. And we refer to some of them, bullying and harassment and so on. And there are particular steps that we need to take in order to address these. What we have done at our court, we have instituted a harassment policy, which has become part of the code of conduct of judicial officers. We have encouraged persons within the court to report on a confidential basis instances of bullying or harassment, and we have established a mechanism for addressing any such complaints. So far as relates to the stress that we have from just doing our work, being exposed to horrible instances of trauma, being in a position where we are suffering from post-traumatic stress as a result of the kinds of cases that we have before us. We have to have a culture within the court where judges are able to disclose on a confidential basis that they are suffering from stress, that they need a break or they need particular coping mechanisms. What we have done is to partner with a psychiatrist in Canada who has been very accommodating in having judges contact him, and he would treat them from time to time. So that there's a variety of measures that can and should be taken to address this issue.
Thank you very much, Justice Sanders. That's important. I mean, there are so many strategies we can take. I mean, I listened to Judge Kelly, a number of the initiatives she has taken, she is still taking. So we can be as creative as possible in making sure we get the Nauru Declaration implemented wherever we are. It's actually to see a problem and ask yourself, how can I address it? The societal circumstances would oftentimes dictate, you know, how some of these things can be addressed. And thank you, Justice Sanders, for that insightful thought. I have a question and I would like to direct it to Justice Matters. And the question is, what efforts are being taken to educate the public on the issue of judicial well-being? We know that, one of the 7 principles is about, enlightenment. So, I mean, what we're doing, for instance, at the ACU is one step. That's an example, but are you happy to speak more on this in terms of what steps are being taken to educate the public on this issue? Thank you.
Sure. This is a very important question, in fact, because among other problems, we feel that sometimes the general public is not aware of the situation. This idea of semi-gods that someone mentioned, completely wrong. Sometimes it makes its way on public domain and people think that we are not like any other humans. So this is a very crucial topic. I think it's a little bit like rule of law. Rule of law, it's in crisis, and the way to try to do different is to educate common people, younger generations, for the importance of democracy, rule of law, judicial independence, etc. There are countries with very interesting experience going to the fairs, to the coffees, to the places where people meet and try to debate about the importance of democracy and rule of law. This is the kind of approach that we have now to do. Once again, only 70 years after the end of Second World War. This is our situation in Europe, for instance. But anyhow, going back to the topic today, I think that there are a departure point that is terribly negative. Until now, especially older generation of judges try to hide the problem, conceal the problem. It doesn't exist. Fortunately, the younger generation of judges, in my opinion, are more open to talk about this. Younger generations know that this is a problem that can be tackled by in a technical way, by therapists, by speaking out, by trying to share experience, by communicate with others. And the older generations of judges and of the public in general was not so open to this possibility. So we have a long way to go. But again, the departure point was so low, nobody wants to talk about this, this doesn't exist, that the simple fact that we are now talking about this, that we have Nauru Declaration, that we can move forward with your help. Academy is essential to help us. And this is a very important webinar also in this sense, that we have Academy joining efforts with us and with the lawyers to try to address this issue. So it is a common effort. And I think also that the public resources should be, this is obviously something very, very common sense, but should be also oriented on this sense. Because as the Chief Justice of Jamaica once said during the Nauru Declaration preparation, if you don't have healthy judges, you cannot have a system, a judicial system with quality. This is impossible.
Thank you so much, Justice Matters. Justice Campbell, would you mind that I come to you for this question? The question says, how should the well-being of judicial officers be prioritized compared to other government bodies? I know I was just listening when you mentioned, the way judges receive protection compared to magistrates, is kind of different in Kenya, and it's a similar thing that happens in Nigeria, where I'm from. And I just thought, I mean, so if the magistrate is attacked, then what's the level of security provided for that magistrate in comparison with the judges? And I think it leads to this question: so how should the well-being of judicial officers be prioritized compared to other government bodies? Justice Jacqueline?
All right, fantastic. Okay, thank you very much. I think, like I said, we have 3 arms of government: the executive, the legislature, and the judiciary. So the executive needs to understand that the judiciaries do not work in competition with them. It's a complementary service. It offers its own people. when we look at the allocation that is given to the judiciaries, you find it's 0.003% of that total government allocation. In Kenya, I believe the other day I heard that it was 98% for the executive. So the other part takes maybe 1.7 and the judiciary takes 0.03. So I advocate for equal treatment of all arms of government, because the kind of job that we do is very, very risky and it has to be done by somebody. Whereas you look at the other jobs, it's really a service that people are offering. But in judiciaries, we are doing a job where one person is a winner and the other person is a loser. So people tend to drag you into their problems. So I believe and I advocate for the fact that our well-being needs to be really prioritized as compared to other arms of government and other institutions. Because and as I finalize, is because if you do not have a social structure, then you cannot even be able to do any other thing. And we are the ones actually who maintain that law and order. The rule of law must be upheld.
Thank you very much, Justice Akama. This question, I would like to direct it again to Justice Kali, because I think you might have some experience in this space. This person says, I'm a lesbian judge in Canada, and I've experienced devaluing and discriminating behavior when asserting my right to healthy, safe work opportunities. Can any of the panelists advise whether they are working with international associations of LGBT plus judges? I think, I mean, what level of protection is given to people who, are in the LGBT community, if anyone has, if you've had any experience in that space, Judge Kelly?
Well, part of our constitution, if anyone wants it, deals with that, and one of the main people involved in the JSN is Victoria McLeod, who is trans and who stepped down from the judiciary this year, I think after 15 years, because of the way in which she was treated in the judiciary ultimately. So things have been good for many years, but there's been much of backlash in England and Wales and other countries, as we know, in relation to gender identity issues, and that was not dealt with as it may have been. We haven't worked, to my knowledge, we haven't worked with the International Association, but the diversity community judges do work with those issues and those people. We now, as of this year, have our own association of LGBTQ plus judges, separate association, who are really helpful in that regard. And I'm not going to say there is or isn't a problem, but because it's not for me to say, but we have a number of openly gay judges, and I'm not aware of them having any day-to-day problems in relation to that. We have senior judges, we have an ex-master of the rolls, we have more junior judges. I'm not aware of that causing issues. Having said that, I'm sure there are, because as there are, some people will not have experienced issues with race. I have. It can vary, but it is something that we're very conscious of, and I'm sure other countries do as well. But there are obviously laws in other countries which are perhaps not as progressive in some as others, and it's an ongoing issue. So yes, I'm not a perfect answer, but an answer.
No, that's good enough. Thank you so much, Judge Kelly. And I would like to use this opportunity to just thank everyone for being here, particularly the panelists. It's 10:29 now, and it's been a very useful discussion, hearing the views and thoughts of everyone. This is definitely has been a remarkable program. I mean, we had over 250 registrations. We've had over 80 attendees here from 45 countries. It's evident, very clearly, listening to everyone, that judicial well-being is crucial, and this Nauru Declaration is an instrument of necessity. So on behalf of the Australian Catholic University, I'd like to thank all the panelists and all the attendees for your presence. I really want to thank all the 18 members of the draft committee for working assiduously so that we have what we have today, and we can be having this discussion. Not all the 18 members are here, but most of the panelists are from that draft committee. So it's a big thank you. Just like Judge Kelly said, it's not just about the now. We're going to affect generations to come, and I just really want to say thank you for what you have done, what you're doing, and what you'll still do. And a big thank you to the panelists for sharing your thoughts and your views, the generosity of your knowledge. And it's evident that we're going to build on this. People are asking, what can we do to get involved? This is all part of the principles, so that we can do some form of public enlightenment and education on this to get people involved and to participate in this. And our hope is that this will be implemented not just locally, but also globally. As earlier noted by Justice Wilhelmina, we really look forward to this Nauru Declaration becoming global, and that we can have a national day where we can continue to promote well-being for judges. And at this junction, permit me to single out Justice Wilhelmina for his cooperation, for his support throughout the process of preparing for this webinar, and not just the webinar, but actually the well-being of judges. I really want to say thank you for all you're doing, and it's noted. It's not taken for granted. This event definitely wouldn't have been possible without your support. And I'd also like to acknowledge my co-host and co-convener, that's Dr. Pickering, for her tireless work behind the scene. She's always very calm, but she makes everything happen. So Dr. Pickering, thank you. Anne Downey, Jennifer Downey, she's quiet. She's the one who's been raising her hand, making sure you keep to time. And fortunately, we've been able to keep to time today. So thank you, Anne. Once again, thanks to all the panelists. Thanks to every single attendee who has been here today. We appreciate the time you've given. I know in some parts of the world it's almost midnight now in Melbourne, where Patrick Hazer is. That's it's almost midnight there. So thank you for staying up at this time. I just really want to appreciate everyone for attending this session, and we look forward to ensuring that we can not just learn about the Nauru Declaration, but be part of making the Nauru Declaration what it ought to be, a place where judicial officers have some form of sanity and well-being. So thank you, everyone, and it was a pleasure being with you. Thank you.
Thank you. Bye.
Thank you.
Bye. Thank you very much, and bye, everyone. Thank you.
All right. Bye, everyone.
Thank you. Thank you very much. Goodbye.